I'm Alan Kenny, Editorial Director with REIT.com, and we're in Washington, D.C. at the Marriott Marquis Hotel for REIT Wise 2016, NAREIT's Law, Accounting, and Finance Conference. I'm joined by Michael McTiernan, partner with Hogan Lovells. So, Mike, you were the former head of the REIT group with the SEC, so you made a good pick to moderate the SEC panel here at REIT Wise. Have there been any notable recent SEC developments related to REITs?
I think probably the most interesting one is just a couple weeks back, the SEC came out with what's called a no action letter, whereby they permitted REITs that are structured as UPREITs to do something that, frankly, we've been trying to get the SEC to let us do for about 20 plus years. And what it lets people do is it lets people who hold operating partnership units, when they're thinking about whether they meet the required holding period under Rule 144, which I won't get too technical here, but basically it's a rule that will let you sell on an unregistered basis shares without having to register them with the SEC. The SEC now changed its prior view and let people add on to the calculation of the holding period the amount of time that OP units were held, such that if you hold them now for more than 6 months, you can immediately sell the overlying REIT common shares upon a conversion of those. What this means for REITs is it actually avoids a lot of what were silly expenses at having those types of transactions be registered with the SEC. So it's a good cost-saving thing for REITs that the SEC just did a couple weeks back.
And I've got two other SEC-related issues I want to get your thoughts on. The first would be the SEC's apparent resistance at using non-GAAP accounting measures. For REITs that aren't using GAAP, do you think that will cause some problems?
It's a little too early to see whether some of the SEC statements about non-GAAP, which as you say, have seemed to suggest more hostility from the SEC on non-GAAP measures that have been there certainly over the last 4 to 5 years, where it's been a little more of a relaxed atmosphere. I don't think that the abuses that have triggered some of the statements coming out of the SEC are relevant to the REIT space. And I think a lot of REIT non-GAAP measures are very well settled. I don't expect the SEC to be changing their views on whether they are appropriate to be disclosed by REITs. I think maybe with some outlier non-GAAP measures that are not consistent in the industry, you may see the SEC pressing a little bit more on making sure that those companies are complying with the non-GAAP requirements.
And the second issue is the proposed clawback rule. How do you see companies adapting?
Frankly, most companies already have clawbacks in place. They probably don't meet where we expect the SEC to come out on this, because most of the clawback policies that I think REITs have now have a fault component baked into them, meaning you would only claw back to the extent that that person was somehow involved in wrongdoing. As you know, the SEC proposed rules that I think are likely to get adopted are a no-fault basis. So I think that what most REITs are going to do is wait until the final rules come out. There will be enough time then for people to amend their clawback policies to get in line on that particular point.
Thank you so much for your time.
Thank you.
And for more on this and other REIT news and analysis, be sure to visit REIT.com.